right, we're back on the record on State versus Ward. Mr. Ward and his attorneys are present. State Attorney's Office is present. I sent you guys an email. Did you get it? On the jury instructions?
Yes, ma'am.
It was my 2-second attempt to define tenants by the entirety. Go ahead while I get the computer up. Defense, you're objecting to something. What are you objecting to?
The proposed tenancy by the entirety's instruction, the state moved to include in the jury instruction.
All,
Eric Braven, B-R-A-V as in Victor, I-N.
all of it? Part of it?
All of it, Your Honor.
Okay.
I don't object to your proposed correction of the misstated testimony of Professor Davis yesterday, although the defense would prefer it be done by stipulation, but if you want to include that statement in the jury instructions, we don't object to that.
Mr. J?
Judge, there is a certain level of authority that comes with jury instructions, and that is because it's the law. In beginning and opening statements, there was this production with a change in tone of voice and hand gesturing about how this tenancy by the entireties and Diane Ward remaining alive was the key to the survival of the Ward empire. And it came out through testimony that there has been some transferring of property to individual spouses during the time of this financial turmoil. And then they brought forth Professor Davis to testify about tenancy by the entireties and how it works. And I believe they even went into how much stuff was being held in the tenancy by the entireties versus individually owned by each other. So it's been made a feature of the trial. They said it was a very important feature of the trial, but the law is, as I have, I believe, pretty well broken down into a few paragraphs in ordinary language that ordinary people can understand. And that's important because what it essentially means is before Mrs. Ward was killed, somebody would have to get a judgment against both him, Mr. Ward, and Mrs. Ward to get at the entirety of the tenancy by the entireties. And after she passed, that would still be the case to get at the entirety of the tenancy by the former tenancy by the entireties and the now tenancy in common. One would have to get a judgment against the estate of Mrs. Ward as well as Mr. Ward. So basically, it nullifies the argument that was made because that's the law. So the jurors are entitled to know the law and what would happen to the marital estate and her individual estate upon her passing if he is found to have unlawfully killed her. That changes the dynamics of what would otherwise occur.
Is that argument going to the issue of whether I'm going to read it as a jury instruction or just the entirety of it?
Well, it's the law. So like other laws, it belongs in the jury instructions. Stipulations of facts, such as the identity of the deceased, that's what a stipulation is. You don't stipulate. Let
me just interrupt you. I'm going to read this as a jury instruction. There was a misstatement of the law from the witness stand. So I'm going to read it as a jury instruction, not as a stipulation, because I think at this point the court has to step in and instruct them as to what the law is in the state of Florida. Now, so the question becomes, let's start with the first paragraph. The defense is objecting to under normal circumstances when one spouse dies, et cetera, which is the one that you drafted, Mr. J. I proposed very quickly, I didn't really edit it much, I just sort of put it down of, when property is held as tenants by the entirety, the surviving party becomes the sole owner of 100% of the property upon the death of the other party.
Your Honor, the defense has no objection to that reformulation of the first sentence.
State, you have an objection to that?
It's technically a misstatement of the law.
What misstatement is there?
Because while they're alive, they're both 100% owners of the tenancy by the entireties per tout, T-O-U-T, And when the other spouse dies, it's not like this person becomes the exclusive owner. It's just that the dead person's 100% interest is now vanished by the right of survivorship into the surviving one. So I believe the way I worded it, how it becomes the exclusive property, conveys the law more accurately.
My concern with the way that you worded it is this: it was the testimony of Professor Davis. I think that for attorneys, the hyper-technicality of what you just said is correct. You're always 100% of the owner when you're tenants by the entirities. But the purpose of the jury instructions is to clarify this for the jury. And my concern is that first paragraph, and I'm not enamored with the one I wrote. I'm certainly willing to modify this further. My concern with the one that you wrote is, again, it's a lawyer's version of the law, which may not clear up for the jury the mistake of law that came from the witness stand. And the purpose of jury instructions is for the jury to understand what the law is. So if you guys want to work on this and try and come up with something that's a little...
What was your language again?
Mine's a little casual. It's when property is held as tenants by the entirities, the surviving party becomes the sole owner of 100% of the property upon the death of the other party. I don't remember the exact language Professor Davis used, but he made it sound as if...
No, it went to the heirs.
Right, it went to the heirs, and I'm thinking you can't divide tenancy by the entirety, so which is why I used the 100%, which is a little casual for jury instructions, but...
But Your Honor, I think you've made the point exactly clear. I think his misstatement of laws, he treated it, or he described what would happen if they were joint tenants. He made a misstatement of law. Your Honor suggested that does need to be cleared up, and we have no problem with that. But through that little pinprick, through this simple explanation of his misstatement of the law, Mr. J now has tried to get in a statute which he asked Professor Davis about, which Professor Davis said he didn't know anything about, which presupposes...
Okay, I haven't gotten to that yet.
Okay.
I'm getting to the second part. Let's
Okay.
just...
So-
the record
so
becomes
I'm happy
hopelessly
to-
confused, so...
Yes, Your Honor.
If you two want to work on clearing up what I put down, I'm
Your
fine with
language
that.
is fine.
You're fine with that? Okay.
For the
Yes, Your
first
Honor.
paragraph, yes, ma'am.
All right, so just, since you're the drafter of the jury instructions.
All right, can you tell me what?
I sent it to you in an email. It's the highlighted paragraph in red.
Do you want me to read it?
Oh.
all? Oh, sorry.
This morning at 8:33.
Correct.
All right.
I did say I hadn't spent a lot of time drafting this.
Okay, yes, I can do that, Your Honor.
Okay. Now, moving on to the second portion of this. Your last name is Braven, right?
Braven, yes, ma'am.
Yes, right. Mr. Braven,
Yes, Your Honor.
what is your objection to the second part, which is the part that begins, however, under both Florida and Georgia law, and explains the unlawful killing statutes that exist? I don't know anything about Georgia law, but apparently exist in Georgia and Florida. Go ahead.
Honestly, Your Honor, I don't know where to begin, and I understand it's Mr.
At the beginning would be good.
Well, I would like to figure out where the beginning is because the motion doesn't make sense to me logically, but here's what happened yesterday with Jeffrey Davis. He testified about tenancy by the entirities. He did make a misstatement of law. Mr. J cross-examined him, raising this Florida statute. Jeffrey Davis said he didn't know about the Florida statute. The Florida statute isn't in evidence. And here's the logic of Mr. J, if I understand it. Remember, as Mr. Cromwell suggested yesterday, the reason this is relevant is going to Mr. Ward's state of mind and to show that under this careful estate planning, he had no motive, financial motive, to want his wife, Diane, dead. Under Mr. J's theory, and again, it presupposes the ultimate fact here and suggests to the jury, and left out of this is that it has to be an intentional killing, and it has to be proven, which is the point of this trial. And it suggests that would happen here. What Mr. J seems to be suggesting is that Mr. Ward, first of all, there was no testimony that he had any knowledge of this statute, and so it's completely irrelevant to the state of mind issue that we've raised. But what he's suggesting is that maybe Mr. Ward, in fact, did have a financial incentive because instead of protecting $9.2 million from his creditors, it would only protect $4.6 million, because half definitely goes into his name, and that he would like to suffer a murder conviction in order to get the other $4.6 to pass through Diane Ward's estate as if he had predeceased her. That makes no logical sense. It is going to confuse the jury, and putting in the jury instructions is going to risk depriving Mr. Ward of a fair trial. I honestly believe if they think this statute is an issue in this case, and they're reading this language, which doesn't talk about it needing to be proven that he intentionally and willfully killed his wife, it is a complete red herring here, and it is getting into the jury instructions, a statute that Mr. J cross-examined the witness on that he didn't have any knowledge of, and that there's not even close to testimony that Mr. Ward had any knowledge of.
Mr. J, response?
Judge, first of all, let's begin with Florida law in regards to second-degree murder. Florida law, contrary to what was just argued to you, does not require intentional killing. But this second part of this tenancy by the entirety's jury instruction is based upon the mistake of law that was espoused by the defendant, starting in opening statements. That is what needs to be corrected as well. The opening statement was everything is awesome and perfect, and the best way to secure the Ward financial empire is for Mrs. Ward to be alive, but it's simply not true. And under King versus State, when they say things during opening statement, I'm allowed to challenge that, regardless of whether they put forth that evidence to follow it up or not. I mean, because that was assuming Mr. Ward knew or understood any of that stuff, and I don't believe Professor Davis's testimony is even putting the state of mind of Mr. Ward wrapped around his estate planning or Mrs. Ward's estate planning. But since they opened that door in opening statements, running the risk of not putting that evidence on, the jury deserves to know the law. And the law is exactly what I've written. And it's not that I am trying to use this as financial motive. This is to rebut their defense. One of their defenses was, he has no reason to kill her because it's going to ruin him financially. Well, but it ends up basically leaving them in the same situation. Yes, half of the tenancy by the entireties becomes his half of tenancy in the commons, but under the math that they've put forth and under the $7.5 million complaint by Bond Safeguard, they would still need to get a judgment against both Mrs. Ward's estate and Mr. Ward to recover that money. So what it is it's to nullify their defense. It's not some sort of financial motive for him to kill her. This is a second-degree murder case. The killing was done out of anger, ill will, hatred, spite during an argument.
The law in Florida is if you're convicted of second-degree murder, you can't profit from the murder. It applies, even though there's no intentional component with Florida's law. But my question is, the issue isn't whether you can argue that. You absolutely can make that argument. And if there was an objection, it would be overruled. The question is whether it belongs in the jury instructions. That's the issue that's being raised by the defense. So why do you think this belongs in the jury instructions? And by the way, we have the jury here. So I'm going to take argument on this and then take it under advisement so we can get through the witnesses, and we'll finish this up afterwards. Go ahead.
Because it's the law, and that's where jury instructions, that's where law goes in the jury instructions. I don't have time now, after Professor Davis's completely inaccurate view of Florida law and tenancy by the entireties, the preeminent scholar of tenancy by the entireties comes in here and says that, and unexpectedly says he doesn't even understand the right of survivorship. I don't have time now to go find a witness to come in and say, yes, I have reviewed Florida statute 732-802, and this is what it actually says. I couldn't even get him to commit to reading it, all right, never mind understanding it. So that's why it needs to be in the jury instructions, because now I'm in a position where I have to get a witness to come in and tell the jury the law. I think that's the role of the court, to tell the jury the law.
Okay. Mr. Braden?
I really appreciate you both reminding me of what Florida law is, and I was not intending to say that second-degree murder required intent. I've read a lot of Florida law, even in New York. I'm referring to 732.802, the probate code that Mr. J wants in, which says any joint tenant who unlawfully and intentionally kills another.
I knew what you were talking about. For the record, I was simply stating that second-degree murder qualifies under our statute, barring you from profiting. So you're citing the probate code to me.
That requires intentional and unlawful killing to even apply to this case at all. So that's what I'm referring to. It seemed like Mr. J was saying
No,
that
there's case law in Florida that second-degree murder, That statute kicks off under the second-degree murder conviction.
It's not in the case law, it's the statute.
Yeah.
One of the
I haven't read the statute, I just know the case law, so.
One of the doctrines of the statute interpretation is to read it in its entirety. And what paragraph 5 says, a final judgment of conviction of murder in any degree is conclusive for purposes of this section. So it's...
I confess I had never read the statute in its entirety. I was simply aware of the fact that under the case law, second-degree murder qualifies under this statute, Mr. Braven.
And it has to be proven that.
Correct, you have to be convicted of it.
Yes, and so.
Mr. Ward hasn't been convicted of anything, so.
Exactly.
His argument, though, is this is the law in the state of Florida, and Professor, he misstated the law, and so now I have a jury that is potentially confused about what happens when someone kills their spouse unlawfully. Let's just use the word unlawfully.
Yes, Your Honor. In relation to a separate subject, when you murder someone, he said it in your state. Your brought and put on more. This is a small area of Florida law. Anybody who listened to Professor Davis in that jury box would be confused about Florida's perspective of this particular issue. And the argument, again, that somehow Mr. Ward subjecting only $4.6 million of his money to his individual creditors somehow defeats the notion that having Diane Ward alive was not a financial protection is absurd.
That's a closing argument. That's not a jury instruction argument. The only thing I'm going to do in the jury instructions is tell the jury what the law is. The problem that Professor Davis has presented for me is that he misstated. We've cleared up the blanket law, but I have concern. Both parties know what I yet, and that his testimony, quite frankly, it was confusing to a layperson. When Mr. J started talking to him about the surviving spouse rule that we're talking about, the probate code where you can't profit from the unlawful killing of another human being in the state of Florida, and apparently in Georgia also, his testimony, if I was a layperson, it would have confused me. It didn't confuse me because I know what the law is in the state of Florida, but I have to make sure that the jury knows what the law is.
But there's no argument that he misstated the law as to this not being able to inherit. As to this particular statute that Mr. J, he didn't misstate the law. He was confusing, but you can't correct every confusing witness's statements, even if it's about the law. Jury instruction, I would propose, to the extent it's relevant at all, because again, as a substitute for Mr. J not being able to put on a witness to correct this statement of law, if a stipulation were to have your paragraph about what happens when a party dies, and to say something like, and if I may read this very short statement, which I think summarizes this, that the surviving party unlawfully unlawfully killed the decedent, in which case only 50% of the property passes to the surviving spouse and 50% passes to the estate of the deceased. Something like that, without 3 paragraphs of this stuff, with a short statement of the law in the form of a stipulation that completely and adequately corrects any possible confusion, and it protects Mr. Ward from having his jury instructions tainted with a completely side issue in this trial.
All right, thank you. I'm going to bring the jury back in so we can continue with testimony. We'll resume the discussion and do the full charge conference when we're done with testimony this morning. I'm still aiming for, unless the state calls rebuttal, closings this afternoon, and I'll confirm with the jury how long they can stay today, because I don't really have a problem with instructing them, closing, let them go back there, talk for a few minutes, go home and come back tomorrow morning. All right?
Thank you.
All right, thank you all. You ready for the jury? All right, let's bring the jury back in. State recognized presence of the jury.
Yes, Your Honor.
Defense? Have a seat, everyone. Good morning. Happy Valentine's Day. Anybody see, read, or hear anything about this case last night? Did anyone attempt to talk to you between the time you left this courtroom and came in back about the case? All right, thank you. Defense, you may call your next witness. You may inquire.
For the record?
Yes, my name is Elizabeth Green.
And Ms. Green, could you tell the jury a little bit about your background?
Sure, I graduated from law school in 1986, and I practice law here in Orlando with the law firm of Baker and Hostetler. I chair our national bankruptcy practice group. I have 58 lawyers who work under me, and our firm has about 950 lawyers.
In April of 2008, did you begin representing Mr. Ward in regard to bankruptcy issues involving the company?
I did.
And do you know a David Landis?
Yes, I do.
And who is Mr. Landis?
Mr. Landis is a bankruptcy commercial lawyer with the law firm of Mateer and Harbor, and he was representing Mrs. Ward individually.
Okay. I'm going to direct your attention to September 21st, 2009. Did you receive an email from Mr. Landis around 11 o'clock in the morning?
I did.
Okay. Permission to approach, Your Honor?
Granted.
I'm going to show you what the defendant is going to mark their second exhibit. Could you identify that email?
Yes, this is an email that I received. I was copying on from Mr. Landis to Mr. Cobart regarding the depositions that were set in the land resources case.
And you were copied on that email?
Yes, I was.
Mr. Cromwell, that hasn't been marked.
Yeah, excuse me. I have to mark it first.
Sorry.
Okay. The official identification B2. Move defense B2 into evidence.
Objection, hearsay.
Sustained.
Did you you were copied on that as part of your representation of?
Yes, I was.
Part of your file that you had?
Yes, so this document was kept in our document management system at my firm, and it was received by me in the scope of working as Mr. Ward's lawyer.
It's kept in the ordinary course of business?
Yes.
Your Honor, I'd move again.
Any objections?
Objection, that doesn't make it a business record.
Sustained.
Was it one of the documents that you relied on in working on this matter?
Yes.
We've addressed.
State you're withdrawing your objection? No objection?
No objection.
All right, this will be admitted without objections. Defense Exhibit Number 2.
Thank you, Your Honor.
That Mrs. Ward would not be appearing on 9/24 for any deposition, that she was not under a court order to appear, and that Mr. Landis was not agreeing to her appearing twice, and therefore he gave Mr. Covert different dates for the deposition, 10/22 or 10/23, I'm assuming, of 2009.
Now, after you got this email, you reviewed it, were you planning to go to the deposition at Mr. Covert's office on September 24th, 2009?
No, I was not.
Do you know Professor Jeffrey Davis?
I do.
And how do you know Professor Davis?
Professor Davis teaches bankruptcy at the University of Florida College of Law. I've guest lectured at his class. I actually taught the advanced bankruptcy class for a semester while Professor Davis was on sabbatical. I was asked by the faculty to take his place.
Now, there come a point where you sent him some financial documents from your files in the cases when you were representing Mr. Ward regarding the bankruptcy litigation of the company?
Yes.
And did you send him some some account documents from SunTrust Bank?
I did.
And did you send him some account documents from, regarding a GenSpring account?
I did.
And how did you get this bank account information?
I received the GenSpring documents from GenSpring, and I received the SunTrust documents directly from SunTrust.
And were these account documents from SunTrust and GenSpring, were these documents part of what you relied on in your duties as far as representing Mr. Ward?
Yes.
And were these documents kept in the ordinary course of business?
Yes, again, they were kept in our document management system at my firm.
In your review of the file, did you see any personal guarantees signed by Mr. Ward?
Yes.
And roughly how much money was signed as far as personal guaranteed by Mr. Ward?
Basically, Mr. Ward guaranteed all of the land resources debt personally and individually, so it was in the neighborhood of millions of dollars.
And as part of your review of the file, did you see any personal guarantees signed by Diane Ward?
Mrs. Ward did not sign any personal guarantees associated with the company.
Right. That's all the question I have at this time, Your Honor.
Thank you. Cross.
Yes, ma'am. Do you still have that Defense Exhibit 2 up there, ma'am?
Yes, sir.
May I approach?
You may.
Now, for the record, this hasn't been stapled yet, but it's 3 pages.
Yes.
All right. So on the middle page, there's an email from you, Miss Green, that says, the Wards, David and I, are available for 2004 exams of Mr. and Mrs. Ward anytime on September 22nd or September 24th. Is that right?
Yes, that was sent on September the 14th.
Okay. And so then at some point between then and September 18th, there was a change of heart, correct?
There wasn't a change of heart. Mr. Covert served a very long document request. I had been asking if Mr. Covert was going to request documents for quite some time. They never responded, and then they responded with a long document request that was impossible to produce in the time frame between the time the request was sent and those dates.
All right. And so ultimately, if these 2004 examinations didn't occur on September 24th, they were going to occur shortly thereafter?
I believe Mr. Landis's email indicates that Mrs. Ward would have been available October 22nd or October 24th.
Third week of October?
Correct.
May I approach the witness again?
You may.
Showing you states 7. Did you get a copy of this email?
Yes, I did.
All right, and so in your course of representation of Mr. Ward, you gained knowledge about some of his personal assets, correct?
Yes, I was representing him individually.
And the marital assets, or what we call the tenancy by the entireties in the law field?
Yes.
And did you learn of any property that was held separately by Mrs. Ward?
Yes, Mrs. Ward owned the house in Atlanta. She owned a lake house, and she owned an interest in an LLC that owned a farm.
All right. And when did she become the owner of those things?
Years before.
How many years?
So I know that she became the owner of the Atlanta house in 2000.
Okay.
And the lake house, I would have to look at the deed. I don't recall, but it was years before.
Now, during these 2004 examinations, it's kind of almost a fishing expedition on financial matters?
So a 2004 exam is a deposition that can be taken of any party in a bankruptcy case. So for instance, if you filed a claim in a bankruptcy case for something, you could be deposed. And what the standard is any questions related to the debtor or the debtor's financial affairs could be asked.
And during the period of insolvency of the corporation or corporations, and then even 4 years back, I believe under the law, the trustee of the bankruptcy can explore every financial move that the corporation had made within that time frame?
Yes.
And so if there was movement of money or assets out of the corporations to particular people, you could explore that with those particular people, correct?
Yes.
All right. And based on the request for document production, it appeared as though the trustee was intending to do that with Mr. and Mrs. Ward, correct?
Objection, calls for speculation.
Overruled.
I actually haven't reviewed the document request since 2009.
Fair
so
enough.
I
It's in
couldn't say.
evidence. No
Okay.
problem. All right. And now, during these 2004 examinations, can other people sit in during them and watch?
Yes, creditors can sit in during the 2004 exam.
Could Mr. Ward sit in during Mrs. Ward's?
Mr. Ward was the corporate representative of Land Resources, so yes, he could.
Okay. Could Mrs. Ward sit in during his?
If Mrs. Ward had a claim in the case, which I don't know if she did, she could have. I don't believe she would have sat through his, but I'm not sure.
All right. Now, you represented Mr. Ward during the pendency of the bankruptcy about Land Resource, LLC, and the 36 subsidiaries, right?
Yes.
Did you also represent anybody in the litigation involving Bond Safeguard Insurance Company versus Mr. and Mrs. Ward and the Daughters Trusts?
I represented Mr. Ward and I represented the Daughters Trust.
Okay. Did you ever represent Mrs. Ward?
I don't believe I represented Mrs. Ward in connection with that litigation.
Okay. All right. Now, for a lawyer to represent multiple clients, you can't have a conflict of interest, right?
Correct.
So the Daughters Trusts and Mr. Ward had a single unified interest, right?
Well, the Daughters Trust didn't really have any assets, so they didn't really have an interest.
Okay. But they were 10% owners of this company? Each?
I don't know that those were the trusts that were named in the Bond Safeguard litigation.
Okay. No other questions?
Redirect.
No, Your Honor.
May this witness be excused.
Yes, ma'am.
Yes.
All right,
Thank you, Your Honor.
You're free to go. Call your next witness.
Your Honor, defense calls Professor Susan Bluck.
You may inquire.
Thank you, Your Honor. Good morning, Professor Bluck.
Good morning.
If you could, you're soft-spoken, so if I could get you to pull that microphone a little towards you.
Okay.
Okay, thank you. Would you please state your full name and spell your last name for the record?
My name is Susan Bluck. The last name is spelled B-L-U-C-K.
And would you tell us what your occupation is?
I'm a professor of psychology at the University of Florida.
Professor Bluck, could you give us the benefit briefly of your educational background?
Yes, I have a PhD from the University of California at Irvine in social ecology. I then went to the Max Planck Institute to do a postdoc degree. I was there for 3 years in Berlin in Germany, and then I got an assistant professorship, began at the University of Florida 17 years ago now, and I'm now a full professor at the psychology department at UF.
Okay, and how long have you been a professor at the University of Florida?
Professor for 17 years. We have steps, and so an actual professor, I guess 4 years, and then before that an associate and assistant professor.
What is your field? What is your subject matter?
I'm the director of the Life Story Lab, so I study how people remember the events of their life with a specific focus on how people remember across the lifespan and how they remember death experiences. I also teach a class on death and dying that I've been teaching for the last 10 years.
As part of your practice, part of your teaching and part of your profession, do you talk about grief?
Yes, absolutely.
Would you explain to the jury, and I know it seems like an obvious question, but could you explain to the jury what's grief?
Right. People probably all have their own ideas of what grief is, maybe from their own life, but from the academic literature, how we would describe it really is a set of emotions, feelings, human emotions, but also thought processes that occur when somebody loses somebody that they care very much about. So that's a kind of a very brief definition, kind of an obvious one of what grief is, but I think the way that psychologists have been thinking about grief recently is sort of different than popular conceptions of what grief is, particularly in the last 20 years. Maybe we've really changed our models, I think, in two important ways, and one of those is that we used to think people went through stages somehow, and they had a lockstep going through these different stages after someone died and they were grieving. But now, after 20 years of research in that area, reviews of that literature are really showing that there's no normal way to grieve. Grief is a very personal and individual thing, and there's lots of different factors that might affect
And
how
that was
people
my next
grieve.
question. Is there?
Oh, okay.
Is there?
I'm kind of in lecture mode. That's just my life, so you'll
Okay.
have to stop me.
That's okay. I just wanted to sort of slow down a little bit and talk about is there a particular way someone should grieve?
Right. Absolutely not. That's what I was trying to get at, that we used to think that there was these stages, but now there's so much diversity in the types of feelings that people have, as well as the kind of cognitions or thought processes that they go through. And that can depend on a lot of different things, like, for example, their gender, what kind of a loss it was, how well they knew the person, their cultural background might affect how they grieve. So all of those things come into the mix. So there's no sort of simple answer to what grief looks like. It's a very personal business.
Is there a difference between in your studies, in your field? Is there a difference now between how men grieve versus how women grieve?
Right. That's one of the things that's really been coming up a lot in the literature lately. Some people have even suggested we should have the term masculine grief so that we don't mix up our view of men because they're not crying or not showing a lot of distress or depression, that men often won't show grief in that way. They'll take what's called kind of a more action-oriented approach to grief. That is, they might not show outwardly what they're feeling inside. And they might also focus on another aspect of grief, which both men and women need to focus on at some point, and that is kind of the problem solving and decision making that needs to go on to repair your life or reconstruct your life. So there's dealing with the feelings that are going on inside, but there's also dealing with how your world has changed and what you're going to do about that, how you're going to repair your family or get back to work, other things like that. So men tend to focus on those, as we might guess, although it's a little stereotypical. Men tend to focus more on the problem-solving decision-making, and women, not all, but tend to focus more on how they feel and then expressing those feelings to other people, sometimes in order to garner social support.
Okay, and is there a misconception out there that if we don't express grief immediately, we're not sad and we're not upset?
Right. That's what, when I was saying at the beginning, there's two things that we've really learned, and that's definitely the second one is that we used to think, psychologists would think too, someone would, present and they're not really depressed and they're not distressed. And it's like, we need to make them that way. There's something wrong if they're not showing those kinds of things. And so psychologists then, after, as I said, a couple of decades of research, have really said, there's maybe across studies, this is ballparking across studies, but there's about 25% of people who show really minimal distress and depression after a loss. And then there's a big group in the middle who show some moderate level of emotion, cognitive disorientation, and so on. And then there's just really a small group who show high levels of distress and depression. And they might do that immediately, but also over years later, and probably need to seek counseling to get help with that.
And how does alcohol or excessive alcohol factor into the grief process?
Alcohol use can be an outcome of grief, so particularly for men, actually. Sometimes they turn to alcohol as a way of coping if they're not expressing emotion or not dealing well with the grief. But also, I think in people's initial responses to grief, alcohol can go both ways. One is that it could really flatten out your affect and make you have even more cognitive disorientation and difficulty dealing with the death. So one thing that happens when people are facing a loss is not only the emotional part.
Narrative.
Sustained.
Give us some example, or an example of things that happen when someone's facing or just suffered a loss.
Yeah, when somebody's just suffered a loss, I think of three different aspects of how they're feeling. One is negative emotion. We all know that part, right? Emotional pain, sorrow, sadness. Another one, though, that's been surprising, has come up in the literature, is some level of positive emotion. So people still remain who they are. They might smile, they might laugh, they might be happy thinking about the person who's gone now, etc. So both positive and negative emotion, which is a bit surprising at first, are part of the initial response. And then also the cognitive aspect or the thinking aspect of it is that your mind is so accustomed to that person being part of your life that you're reeling and going through some kind of confusion, numbness, cognitive disorientation, saying, what happened? Why did this happen? Is this really final? Did they really die? And sometimes that can last for days or even weeks, that the person knows that someone has died, but they are not really sure of it.
Sustained.
Thank you.
Now, with respect to
People's reaction to grief, can that be affected by whether they're in the presence of strangers, authority figures, or in the presence of loved ones?
Objection, relevance.
Sustained.
Is it a possibility that someone is feeling grief but not expressing it the way we would expect?
Yes, I think from what I was just describing, that's definitely the case. Another thing to always think about with grief is what the person's feeling and what they're expressing, but then also the context in which they're expressing that. So there's in the grief literature something called hidden grief. That is that I might be feeling one way, but I don't feel comfortable, for example, in this courtroom, that I wouldn't start crying about my mother's death. I'm in a professional setting, and I'm not going to show those emotions right now. So in institutional settings, particularly where there might be an authority differential between you and the other person that's there, they're kind of structuring the conversation, and you may not display your grief in the same way you would with a friend or family member.
That's all the questions I have, Professor. Thank you.
Okay, thank you.
Cross.
Would you agree that people make mistakes?
Yes,
And can you regret your mistakes?
absolutely.
So even if you have regret, remorse, sorrow, grief, that has nothing to do with whether or not you made a mistake, right?
What's the question?
You can have regret, sorrow, and grief, whether or not you're responsible for the thing that's making you sad or not.
Right, I'm not sure if you'd have regret if you didn't cause it, but you certainly could have sorrow and grief.
Okay. All right, and all this research that we've been talking about, we're talking about the lifetime of a grief event, which is much more than 5 minutes, right?
Absolutely.
Okay.
Sort of beginning right off the loss, right after the loss, and then going out from there.
Okay. And you also said your focus area is on memory.
Mm-hmm.
Is that a yes?
Yes.
Sorry. And a couple of factors that affect the reliability of your memory would be whether it's an emotionally significant event, correct?
Right.
And the recency of that event, correct?
Mm-hmm.
That
Yes,
yes?
both of those can have some effect on whether you remember events in your life.
Thank you, Dr. Black.
Redirect? All right. Thank you, Doctor. You're free to go. Call your next witness.
Your Honor, defense called Dr. William Anderson.
You may inquire.
Thank you, Your Honor. Good morning, Dr. Anderson.
Good morning.
Would you please state your full name, spell your last name for the record?
William Robert Anderson, Anderson.
Dr. Anderson, what's your profession?
I'm a physician, medical doctor. I practice in the area of pathology.
Would you give us the benefit of your educational background?
I attended medical school at the University of Miami. I did training in pathology, which is basically the basic science of medicine. We do tissue diagnoses, autopsies, biopsies, and so forth to determine diagnoses of death and injury and so forth.
Did you undergo any other education after you left the University of Miami?
In pathology training, I trained at the University of Rochester in New York, Duke, and University of North Carolina. And I trained in 3 areas of pathology, one of which, as I mentioned a minute ago, was anatomic, where you do tissue diagnoses. If you have a biopsy done, the pathologist reads that biopsy, makes the diagnosis. We also do autopsies, and we also in clinical laboratory medicine. When a test is done, the pathologist is the one that's basically running the laboratory that does your testing and so forth. Now, another area, a subspecialty of pathology, is medical, legal, or forensic pathology. I also trained in that area and was trained at Chapel Hill, North Carolina. In the medical, legal arena, what we do is we use the information we know as pathologists to interface with the legal system. The
Objection
usual
to
medical
the narrative.
exam.
We've transitioned
Sustained.
from education.
Doctor, are you board certified?
Yes.
In what?
Anatomic, clinical, and forensic pathology.
How long have you been board certified?
I've been board certified in forensic and anatomic since 1976 and clinical pathology or laboratory medicine since 1980.
Can you give us your employment history?
Well, I was medical examiner in Los Angeles, in Georgia. I was deputy chief medical examiner in Orlando, the District 9 office from 1990 to 2002. And since then I've been in private practice. I do consulting work as I'm doing today. I do private autopsies. And I also, at this time, I do I'm laboratory director for 2 centers that do gastrointestinal biopsies. And I read those biopsies for patients.
You mentioned autopsies. How many autopsies would you estimate you performed in your career?
Well, I've probably done somewhat over 7,000, maybe close to 8,000 myself. And when I was with the medical examiner's office here, we had a training program that pathologists who finished their first part of pathology training could then train to become forensic pathologists. And I was the director of that program. So during those years, about 6 or 7 years we had that program, I supervised the resident doing the autopsy on those cases. There was about 300 a year, so there'd be probably another 2,000 or so.
Okay, and you mentioned that you actually worked as a medical examiner here in Orlando.
Yes, I was deputy chief medical examiner here in Orlando.
Are you a member of any professional organizations?
Well, I belong to the American Medical Association, the National Association of Medical Examiners, the U.S. Canadian Academy of Pathology, the American Academy of Forensic Sciences. I think that's about it at this point.
Thank you. Have you reviewed some materials as they relate to this case?
Yes, I reviewed materials, and I also, in this particular case, had done a second autopsy on the deceased.
Okay, so you reviewed the autopsy report of Dr. Stephanie
Yes,
and all of the accompanying findings, toxicology findings?
yes,
Did you also have an opportunity to review the photographs relating to the gunshot test or the gun test?
yes.
Okay. Did you, and I think you mentioned this, you actually performed a second autopsy on Mrs. Ward, is that correct?
That's correct.
So let me ask you this. When you were reviewing the autopsy performed on Mrs. Ward and the second autopsy you performed, did you have an opportunity to test the stomach fluid that was taken from Mrs. Ward's stomach?
No. When the first autopsy is done by the medical examiner, all the fluids, blood, so forth, are going to be collected. So the second autopsy, basically, we don't have any access to that. It's already gone, been collected, whatever.
Okay. So my question is, did you weren't able to review the contents of Mrs. Ward's stomach, correct?
That's correct.
Why?
Well, as I indicated, it was not there at the second autopsy.
Was it tested?
I don't believe it was tested.
Okay, who would make the...
Reading the reports, no, I don't recall that it was tested.
Okay. Should it have been tested?
Well, it's always a good idea as a scientist. What we want to do is collect all the data we can in a case. We don't want to presuppose anything that this may have happened, so we don't need to do this, and this may have happened, so we don't need to do that. The idea of the scientist is you collect everything before you come to conclusions. So if you have, for instance, full toxicology, gastric contents, urine, blood, so forth, you test everything. For instance, urine sometimes will contain substances that have gone...
Stop you there, doctor, because that was my next area. Did they test for urine?
No.
Should they have tested for urine?
Yes.
Why?
The reason you test for urine is because sometimes a drug will be cleared from the bloodstream and still be present in urine. That's why when they have urine drug screens for employment and so forth, that some of these things may hang around for several days, even weeks. So you may get an idea that something was used that isn't necessarily present in the blood at that time, but it's still something that the person has been using. So that's why, again, you want to know one way or another whether it's true. If it's negative, it's negative. If it's positive, then you know you've got more information to deal with. But if you don't do the testing, you'll never know whether or not that was there or wasn't there. So as a medical examiner, good practice is to do all the testing you can on everything you need to, and not presuppose that you know what happened to the person, because sometimes you can be surprised the test will come back with something you never expected, and if you don't do that test, you'll never know that.
Okay. So as part of your review of this case and as part of your second autopsy, did you review photos of the scene where Mrs. Ward passed away?
Yes.
Now, is that important for you to review in doing a second autopsy or in this situation?
Oh yeah, we're doing the first autopsy. I mean, we wanted to know the basic, there's a difference between what we call hard data, which is actually the facts of what we see and what we know and so forth, and soft data, which somebody says something happened or law enforcement said they think something happened, that's soft data. And when you're doing an autopsy as a forensic pathologist, you want to keep everything in the hard data range. So yeah, we looked at the scene and pictures of the scene, which is hard data, without anybody giving an opinion as to what they thought happened at the scene, but just the hard data.
Okay, when you reviewed the scene, had anyone
Importantly, next to where the major amount of blood was present on the wall.
should have?
Yes, in my opinion, they should have, because, well, in a gunshot wound, particularly to the head area, which is highly vascular, there's going to be the wound is inflicted and the heart is beating. The first beat is basically going to pump blood into now an open space. You've got the blood coming out of the nose, coming out of the mouth, and so forth. So the first beat generally is the most blood is in that area. And then there can be secondary blood spatter, all sorts of things can happen then. But so the important thing is to know, was the gun discharged with close to where that large amount of blood was. And since that's right on the wall, if you put the victim in a position leaning over toward the wall, the gun being from a fairly close range, intermediate range, below the, for instance, there might be gunshot residue on the wall because the wall is right next to where the gun is being discharged. So that would be something you'd want to know. Now, in a scene like this, anything is possible. But you have probabilities are that the victim's head was close to the wall when the gunshot went off. Now, if you,
Let me stop you there if I could, because you talked about range in your answer just a moment ago. And I want to ask you about range. Is it part of your job as a medical examiner to at least come up, let me ask you a better question. Is there any way any medical examiner, you, Dr. Stephanie, or anyone, can give an exact range as to where the gun was from where the bullet ended?
no, all we can do is give an estimate based on the pattern of the stippling in this case, the burning powder and the tattooing, and the then the results of the test firing of the weapon. And this would be, I looked at the pictures, and I looked at the photos, and I looked at the body when I had the body, and my best guess would be intermediate. It's a little bit greater than the 12-inch pattern, and not more dense or closer than the 18-inch pattern, and certainly much denser than the 24-inch pattern when they did the testing. So put it there between 14 to 18 inches or so.
Could be less?
It could be a little less, but if you get in much closer than 12, the pattern was denser. So I think it was probably, I'd stick with 14 to 18, maybe
Okay.
even 20.
Fair enough. I want to ask you about the trajectory. Did you do any work to determine the trajectory? First
Well,
of all, explain to me what trajectory is.
all right, that means the path of the bullet through the victim, whatever area that happens to be. In this case, it enters in the left side by the nose, and you have a little stippling on the face, and then it goes upward a little bit. It comes in at 4.5 inches, and it's bound at 3 from the top of the head. So it's going to go up that way. So if you put an individual looking down like this,
Doctor, we can't hear you now.
I'll demonstrate, then I'll talk. In that position, with my lavalier microphone, in that position, when you put it in the anatomic position, it looks like it's going upward, but not necessarily, because if you have the head downward, it can be straight on with the head at an angle. So you really, and in a situation of particularly gunshot wounds, you rarely know the exact position of anybody when the shot actually is fired. Because we're just looking at a snapshot in time. We don't know what happened seconds before, and we don't know what happened seconds afterwards. So we're just looking basically at a snapshot.
With respect to the toxicology aspect, when you reviewed the toxicology, did you become aware that Mrs. Ward had citalopram in her system?
Yes.
You know what the level was?
I recall it was a fairly high, the level they found was a fairly high if it had been the actual steady state level. But what happens, and I'm sure the toxicologists have gone through this ad nauseum with you, but when the drug first goes into the body, it comes in at a higher level because it's all being absorbed. As it goes through the liver, it begins to drop down, and then you have a steady state. And that's basically what all the levels are based on, is a steady state. So if you happen to get somebody who just took the drug, even though they may have taken either the prescribed amount or even a little more, you may get a higher peak level. And then as it goes down over a period of time, it goes down further, and that's the trough. So that's why you have to take, like every 6 hours, you have to take another medication if you want to keep that level maintained. But if you happen to catch it right at the peak, it looks like it's going to be an overdose, but actually it's not, because you go down, it would have been a steady state had the person liver had a chance to metabolize it, and that's what all the data is based on, is that steady state.
Now, with respect to citalopram or Celexa, how about alcohol? Was there alcohol in Mrs. Ward's system?
Yeah, she had some alcohol.
Would that be a 0.11?
I think it was a 0.11 or a 0.12.
Okay. I want to ask you your opinion about the combined effects of that level of alcohol and the level of citalopram you found in the toxicology reports that were in Mrs. Ward's system when she passed away.
Well, as any drug, there's a lot of individual variation, but I would say that citalopram aggression, that sort of thing, in some people it doesn't. So you really can't, based upon just a drug level. Plus, it may well have been that she was, as I said, she was at her peak and not in her trough. So we can't necessarily say that she had a high level or higher toxic level of citalopram because we may have just caught it at the peak. That would have been one of the advantages of testing the gastric, because we would have been able to tell how much of the actual pills were still in the stomach. And if they had gone through, then we'd know that we were down in the trough phase and it really was a high level. But if it had a lot of the actual pills still there and she's still absorbing, then we would say, okay, we're at the peak. So that's why it really is important to test that. And also the urine for the same reason, to see what else her level had been if she was taking other medication that just didn't happen to be in the blood at the time.
Well, we know, the only thing we know is what was tested, right?
Correct. But as I say, as a scientist, you want to get all the information you can before you come to conclusions.
We know there was an elevated level of citalopram.
Yes.
We know there was alcohol in excess of the legal limit.
Correct.
My question to you is, what possible side effects could that combination cause?
Well, as I said, they could cause, alcohol in itself can cause problems with the sensorium, although it was above the level of driving level for illegal intoxication, but it wasn't anywhere near toxic range. So it could have behavior problems. It could augment the changes with citalopram, for instance, make it more aggressive. It can go the other way, make more sleepy and so forth. I don't think it's certainly not incapacitating in any way, but it's so variable from different people. I think it's somewhat hazardous to say, well, this would have happened, boom, 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 or this would not have happened.
And I don't want you to say what could have, because no medical examiner anywhere can tell us what happened in the ward bedroom that night, correct?
Absolutely.
Okay. But with that combination, as you discussed, could, I'm not saying did, could that combination cause a side effect of aggression?
Well, citalopram by itself can cause some aggression and anxiety reaction and so forth. But sure, combined with that, it could conceivably do that. But I don't think we could necessarily say one way or another in this particular instance that was the case.
Understood. And could it have caused hallucinations?
Usually it's a toxic level to cause hallucinations, and I'm not convinced this was a toxic level. But it could certainly cause changes in the sensorium, in other words, how you perceive things and so forth. As you know, alcohol itself can do that, obviously.
What's the sensorium?
In other words, how you perceive things, your mental status, are you taking in what's actually happening, or are you is it getting fuzzy?
Doctor, that's all the questions I have. Thank you.
Cross.
Yes, ma'am. Good morning, Dr. Anderson.
Good morning.
How tall was Mrs. Ward?
I don't recall. I'd have to check the autopsy report.
Do you have that there?
No, I don't have it in front of me. I'm glad to show it to me. I'm glad to.
No problem. May I approach with what has been bait stamped in discovery as page 163?
You may.
Paragraph labeled general statement, I think, might have the answer.
Okay, she looks like she's 67 and a half, and 151 pounds.
Oh, I didn't ask her weight. All right, so 67 and a half, that's 5'7" and a half?
Yes.
All right. And I know everybody's different, but did she have unusually long arms?
I wouldn't necessarily say that, no.
Okay. All right, now, you talked about where this happened in Mr. and Mrs. Ward's bedroom. You said something about being close to the wall?
Judging by the amount of blood that was present would suggest strongly, and not completely exclude other possibilities, but suggest possibly that after the gunshot wound was inflicted, a large amount of blood came out basically first beat of the heart. And all that blood, the majority of the blood, is on the wall and then dripping down, and then obviously where she lay. There is some evidence of blood spatter, which is blood coming off when the wound's inflicted, and that may have been the reason there is some blood spatter on the wall, and there are also some blood spatter on the carpet, which may have been, instead of dripping blood, may have been the other. Is that absolutely 100%? No. Could something else have happened? But my point was, if we knew, for instance, if we did find gunshot residue on the wall, we would know that that was the case. But
All right, let me stop you there. And there was projected blood pattern on the bedspread as well,
well, there was some, yes.
and projected blood spatter on Mr. Ward's right shorts.
I believe there was. I didn't check out his clothing particularly, though.
Okay. And there was drip pattern on the carpet as well?
Well, the problem is you're saying it's drip pattern, but it also could be spatter as the blood's going out. It could land there also.
What's
So-
your background on blood spatter analysis?
Well, blood spatter analysis really isn't accepted by the American Academy of Forensic Sciences as a specific science. It's sort of very, shall we say, it's soft science, and it's pretty well been accepted. But my experience basically is when I've seen blood cast off from wounds, and I know particularly the amount of bleeding that occurs when a gunshot wound is inflicted. And that's basically what I'm basing it on.
I'm just
couldn't say
asking.
for sure it was drip, but you can't tell the difference between drip and blood spatter that's been
All right,
cast
well,
off.
let's say this word. Did you see the blood pattern on the carpet as well?
Yes,
All right. And so you've considered all the different patterns, maybe not necessarily Mr. Ward's shorts or shoe, but the bedspread, the carpet, the wall, and Mrs. Ward, correct?
correct. And in a position that if the victim is in a position with head down facing the wall, partially facing the wall, and the gunshot wound creates spatter, it can spatter out. But the more critical thing, in my opinion at least, is that the large amount of blood is going to be coming at basically the first heartbeat after the wound's inflicted. And the majority of that blood is not by the bed, it's by the wall. So I mean, it's not the only possibility, but if the individual is near the wall and you found gunshot residue on the wall, if you tested that, then you'd be able to either prove me right or prove me wrong. But the gunshot wound residue was not tested, which I think is a big problem.
What's the diameter of the gunshot residue event caused by a .357 Magnum?
I don't know, it depends. First of all,
If you don't know, the answer is I don't know.
I don't
Thank
know.
you. Let's try and narrow this down to yes, no, I don't know, okay? So you also said that you shouldn't assume things during your direct examination, correct? Yes or no?
Yes,
And you just in one of your last answers said, assuming that her face was facing downward at the wall. Did you not say that, correct?
as one of the scenarios, yes.
All right. But as you also said, we have no idea based on the autopsy where her head was in relation to the standard anatomical position, right?
Correct, absolutely. We don't know the position of either the shooters, if they both were struggling with the gun, or...
All right, we'll cross that bridge. Right now, you've answered my question of yes or no. And so we don't know if her head was turned to the left or to the right in respect to the anatomic position, right?
Correct.
And we don't know if it was facing up. We don't know if it's facing down based on forensic science, which is all you should rely on, correct?
Yeah.
And you don't know whether she was bent over, standing up, or not based on the anatomic science from the autopsies, correct?
Correct.
All right, thank you. Now, you didn't review Mrs. Ward's medical records, did you?
No.
And so you have no idea how long she was prescribed antidepressants, did you?
No.
And you have no idea how long she was prescribed citalopram or Celexa, the brand name, correct?
That's correct. It was in my,
You've
in
answered
my
the question.
analysis, it was, no, I did not review the records.
All right. And you have no idea how long she was prescribed the current level of dosage of that citalopram either, correct?
Correct.
And you have no idea how long she may have been reporting to her doctor that she drank alcohol, correct?
That's correct.
Or how much alcohol, correct?
Correct.
And with what frequency, correct?
Correct.
And you don't know whether or not her doctor was aware that she was drinking all this alcohol, but still...
Well, that's, yeah, to save time, that's not part of my analysis at all. So
Okay.
I didn't consider any of that. And as I said, I did not review the medical records, which pretty well covers your last 7 or 8 questions.
Well, how long a person is on a certain medication, such as citalopram, affect how much of the drug is built up inside the tissues of the body?
No, not necessarily. It depends on if they're still maintaining a steady state. Presumably, it will not get beyond that level.
So the answer is not necessarily?
Right.
And as a pathologist, you want to do everything you can to understand what happened to this person, such as examining stomach contents and urine bladder contents, correct?
Correct.
But not reviewing medical records, correct?
Well, the issue is only what was present at the actual time of the shooting, not what had happened before or what the private medical history was. We're looking at what was happening right at that moment, as I said, the snapshot of the actual time that the victim died. So that's what we're looking at. We're not. There's so many variables to go back and try to figure what somebody was taking stuff for a long time. So people take medications for a long time and still have untoward reactions occasionally to them, even though they've taken the same medication.
All right.
So, but that's not part of the analysis that the forensic pathologist does.
Okay. Now, you testified today that the level of citalopram in her blood was not a toxic level.
Correct. Well, I would say we cannot tell if that was the peak level or if that was the steady state level. And the problem with not having more information than that is you can't assume that the peak level is toxic, because the level may eventually would have come down to either a normal or maybe slightly higher than normal level. But all the toxic levels, the determination of toxic levels is based on the steady state of the drug. And it does not take into consideration what the peak was. And if she took this 10 minutes before, it may have been going to come down to normal level and wouldn't have been toxic. So we don't know that. And the advantage of doing the stomach contents would have been that would have given us a clue as to whether or not there was a lot of pills still in the stomach, or if it was beginning to go through the gastrointestinal tract and be absorbed.
Do you remember giving a deposition in this case on January 26th of 2011 in Altamont Springs?
I probably did. I remember giving a deposition. I don't know the exact date.
All right. And in all likelihood, it would have been at Marge Rader's office in Altamont
Most
Springs?
likely, yes.
We spend so much time there together.
We do.
Okay. May I approach the witness with page 11 of this deposition?
You may.
If you would, probably starting with line 15, could you read to yourself down to 24?
Okay.
So did you give the following answer to the following question at that time? Question correct? Answer, but I'm saying it's not an overdose of that. It's the citalopram, however, is a very high level toxic. Did you give that answer?
Yes.
And today's answer is maybe.
No, I think I further explained, or I explained that if that level was the steady state, it would be a toxic level. If that level is early on in the peak phase and it's going to come down to a lower level, then it's not a toxic level. So we're basing it upon, well, we don't know. And the problem is we don't know if it's the peak or not, because the gastric contents and results are not available.
All right. And the gastric contents were reported to be 10 milliliters of pink fluid, correct?
Yes.
And no report of there being pill residue, correct?
Well, the pills.
Yes or no, correct?
Well, there was no pill residue, but that doesn't mean the pills aren't there. You don't. We have.
Dr. Anderson, please answer my questions.
I am answering
They can
it.
ask you some
No,
questions.
I'm answering your question.
Was there any mountain of powder reported being there, like when my protein shake doesn't stir well?
No.
Okay, thank you. Now, would you agree that the people in contact with her that day would be a better source of information about her behavior?
Well, it depends on who the people were, I guess. I don't know. We're not talking about her behavior. We're talking about what was going on at the instant that this thing happened, the snapshot of what went on. So I don't know how to answer that question. Her behavior, to me, would be immaterial, but prior to the actual event.
All right, so if I were to ask you, quote, people that would have come into contact with by speaking to Mrs. Ward may have a better idea of her frame of mind that day, what would your answer today be?
Well, sure, but that her frame of mind at the moment that this has happened would be difficult to assess by trying to figure out what happened earlier in the day. Too many things change. People have committed acts of aggression, after being normal for days and days in their life, and suddenly something happens. So to try to take a snapshot and go back and see what prior behavior related to the present behavior, first of all, is not part of what the forensic pathologist does, and secondly, it would be fraught with hazard, I would think.
And so, for instance, I could throw a glass of wine on somebody and I may be completely sober, right? When I do it, I don't have to be drunk or hopped up on medication to throw a glass of wine at someone, do I?
Absolutely.
Okay.
No,
All right, so.
I hope you don't have any wine with you today, but.
Not yet. Now, before a proceeding in 2011, you had indicated that your research on citalopram had involved exclusively looking at a webpage called Medscape.
Well, as far as the clinical effects, you have Medscape.
Dr. Anderson, it just calls for yes or no. Is that true?
Well, not exactly. As far as the clinical effects, obviously I'm familiar with the toxicological effects from all the forensic texts.
Since then, have you done any additional research on it?
No, I don't believe so.
Okay. And so, do you have to be a medical doctor to be able to get an account to go onto Medscape?
I don't think you do.
I don't think so either. And so when you say hallucinations, anxiety, and aggression, is that the complete list of side effects for this particular drug?
Oh no, there's a long, long list of side effects: nausea, vomiting, diarrhea,
somnolence, lethargy,
impotence, a whole bunch of things.
Can affect your balance.
Probably, yes.
All right. And so do they actually even assign percentages to how frequently these side effects are reported in people in studies?
Well, they do. They put the side effects are in percentage of reported cases. Now remember that those are reported to the drug manufacturers, and they put that in their handout.
So what was the percentage reported for, say, anxiety caused by this?
I don't know. It was about 3%, I think. They were all run around 1 to 3%.
All three of the ones you mentioned: anxiety, hostility, hallucinations.
Sure.
How about somnolence?
I think somnolence was even less, or maybe 1%. I don't recall. All of them were either 1 to 3%. So it wasn't a high incidence. If it's a high incidence, they're going to probably remove the drug from the market.
May I approach the witness?
You may.
For the record, I've showed defense counsel, and now I'm showing you. It's a website called medscape.com, and I entered citalopram, and then I went to the adverse effects.
Okay.
Now, obviously, this is today and not 2011. But would you rely upon this today as well, this
Yes,
website?
yeah.
All right, and so for somnolence, what's the percentage reported?
Okay, about 18%. Nausea, 21%.
Okay. Anxiety?
4%.
Confusion?
1%.
What's the little arrow?
Less than 1%.
Okay. All right, now you said the urine contents, that would be something that's not reflective of what's in her blood at the time of her death, correct?
It can be, yes.
Okay. Now let's talk about manner of death. Did you make a decision about manner of death in this case?
No, as a medical examiner, we determine whether or not a case is homicide, suicide, accident, natural, or undetermined. In this,
I'm sorry, is that not manner of death?
that's what I say. That's what medical examiners do.
Okay.
In this particular case, my experience has been this type of gunshot wound has been seen in accidental deaths
Doctor, can I stop you there? What my
Well, you asked
question
me
was,
if I-
did
if
you
I
decide
determined-
a manner of death in this case? Yes or no?
No, in my opinion,
All right.
as I was explaining.
Let me ask you the next question. So out of those 5, did you narrow it down to 2?
Yes, I think it's,
That's the answer to the question, okay?
okay.
Which 2 did you narrow it down to?
Between inflicted by another, which would be homicide, or accidentally inflicted by one or more individuals.
Okay. You ruled out suicide, correct?
Well, normally,
Is that yes or no?
yeah, I think the range of
Yes or no? Did you rule out suicide?
as a probable cause, yes.
Okay. Now, let's talk about what that means. Manner of death, that's a forensic pathology term, correct?
Correct.
So it's not the same thing as the legal decision the jury's going to be asked to make at the end of the case, correct?
That's correct.
And so you haven't considered things like the defendant's 911 call, correct?
No, the medical examiner
So
basically,
no is your answer? You did not consider that, correct?
that's correct.
You did not consider an email that the defendant sent to several attorneys that night, correct?
As I indicated, that we stake with the hard data in the case directly related to the pattern of injuries, and that's what the forensic pathologist does.
Okay.
We don't deal with soft information, what somebody might have done, as I indicated early on, what somebody might have said, might have thought, whose theory was this. We get we go with the preponderance of the actual facts that we have at the time. In this particular case, I would have difficulty distinguishing between an accident and a homicide.
All right. And the answer would be no, you did not consider his interview, his being Mr. Ward's interview to Channel 13. No, you did not consider the wine on his shirt. No, you did not consider the broken glass and the wine on the patio, correct?
That's correct.
Okay. Now, in ruling out suicide, you factored in the range of the wound, correct?
Well, you can never actually rule out anything, because there may be further information available. But generally speaking, when someone is committing suicide, they attempt to make sure that the actual wound is effective. And holding a gun 14 to 20 inches away or so and hoping to shoot yourself with it is pretty unlikely. So
Okay.
that generally, not 100%, but that generally rules that out.
Now, because of this range of this particular gunshot wound being intermediate, as you said, that is a factor in you not being able to say it wasn't an accidental struggle, correct? Is that part of your basis of your opinion that this could have been a struggle?
I think it could be an accident. I think it could be a homicide. I don't think we know. If people are struggling with a weapon, we can't be sure what the distance was, although it certainly was close enough that it could have been an accidental shooting in those two individuals struggling with a weapon.
Well, that's what I'm getting at, is your basis for your opinion that there was a struggle over the weapon. Your forensic basis based on hard data, not soft data. So my question to you, Dr. Anderson, is the range of the wound, since it's intermediate, still within arm's length of the person shot, was that a factor in you not ruling out an accident?
Yes.
Thank you. Now, you also talked about the trajectory. Was the slight upward trajectory also a factor in you not being able to rule out an accident, correct?
Yes, because we don't know the position of the shooter or the victim at the time the gunshot wound was actually inflicted.
And so why forensically is a slightly upward trajectory when you don't know where either a person who may or may not have been there with her or her, what their positions are?
Well, upward trajectory, we're referring to the anatomic position with the body in basically upright position, measuring the wounds. As I indicated, because you cannot tell the position, what appears to be upward may not actually be, depending upon the position of the head at the time.
Do you believe that the gun could have been below her waist at the time it was discharged?
Possible.
And there was no blood on the gun, correct?
I'm sorry, I didn't understand. I don't know that. I don't know if there's blood on the gun or not.
Well, if the gun is below her and she projects blood, would this force of gravity apply to the blood?
It could.
And the force of gravity is pulling everything and everyone towards the earth at 32 feet per second? Yes or no, or do you not know?
Well, yes.
Okay. And so there's no blood on the defendant's hands either, correct?
Correct.
All right. But the gun could have been below her waist when it was discharged, correct?
Right.
Okay. Thank you. Now, you examined the pictures of the scene, correct?
Some of them, yes.
Did you examine the ones
related to the body?
Did you examine the ones with the measuring tape on the bed?
I think I saw those, yes.
And so you would agree that the projected blood onto the bed goes about 11 inches?
From the edge of the bed. Well, I don't recall because that's not part of my analysis.
All right. The photograph would be the photograph. You'd
Yes,
agree?
correct.
Okay, thanks. And you looked at the height of the blood pattern on the wall that you say is projected from her heartbeat, correct?
Yes.
And what about how high was that up off the ground?
Well, I don't know the exact height, but it was at the level of the chair rail and down.
So the photographs with the measuring tape would be the best source?
Sure, yes.
All right, thanks. Now, you agree that there's no defensive wounds on Mrs. Ward, correct?
Yes.
And to you, that indicates that there was a struggle or not a struggle?
Well, one of the hypotheticals we talked about was that it was to happen during a struggle. But there was no defense wounds, and I think that's basically all we can say about it.
Okay. And your testimony would be that there's no spatter on her hands?
I don't recall if there was any spatter on her hands, and there was, or not.
May I approach the witness with page 14 of his deposition?
You may.
Paragraph from line 7 to 14. Read to yourself.
Correct, okay.
All right, and so what is your testimony? Was there spatter on her hands or not?
No, I didn't think there was spatter. There was transfer blood, but there was no spatter. And I believe there was gunshot residue found.
All right, again, you have a medical license, correct?
Correct.
That allows you to perform autopsies,
Correct.
and I have a law license, as far as you know, right? I'm here.
Well, it's 10:30. I hope so still.
All right, so my law license allows me to ask you questions about what you did with your medical license, okay? So if you would answer my questions instead of your questions, I would appreciate it. Now, you agree that your testimony is that there's no spatter on her hands, correct?
Correct. My opinion was there was transfer blood.
All right, and the photographs of her hands would be the best evidence on this issue, correct?
Correct.
All right. And in your research over the years, I know you said that blood spatter is not a hard science. Have you ever reviewed any materials written by Stuart James?
Probably.
Now, the fact that there's no spatter on her hands to you means that her hands were not up protecting herself or defending herself, correct?
Correct.
All right. So you say there's a struggle over the gun forensically, correct?
Correct.
So where are her hands during this struggle if they're not on the gun and not up?
Well, we didn't say they weren't on the gun, but the individual could be in a situation where she's leaning forward. The gun is back here. The blood is projected outward like this, and the hands and the gun are actually protected from the blood spatter by her portion of her body and her clothing and herself. In other words, it doesn't have to necessarily, if it's over in this position and the blood suddenly comes out this way, it doesn't necessarily go on the gun if it's down by the hip area.
All right. And you believe that there were no evasive or defensive maneuvers made, and that supports the conclusion that this could be a struggle, correct?
Well, I'd say there are no defensive wounds. As far as evasive movements of the individual prior, I will go back again to say that we're looking at the snapshot of what actually was present just at the time that was fired. and we don't know anything about evasive maneuvers or anything like that.
May I approach the witness with deposition page 17 and 18?
You may.
I'm going to ask you to read from line 23 on page 17 down to line 4 on page 18 to yourself.
Where to where?
Question at 23 down through the end of that paragraph.
Okay.
All right, and so did the lack of evasive maneuver have anything to do with your analysis about whether this was a struggle?
Well, there was no evidence of an evasive maneuver, such as putting your hands up in front of a gun that's being fired. That was my answer to your question at the time, whoever took the deposition.
Yeah, it wasn't.
So we have no evidence of defensive wounds. But your question was, did she make any evasive maneuvers before she was shot? Well, we don't know that.
Right.
We're talking about what we have evidence of, and there was no evidence of an evasive maneuver.
Now, at the time, her blood alcohol level was 0.113.
Yes,
Does ethanol affect one's reaction time?
it can.
And she had some trazodone in her system as well,
Yes,
and that's a central nervous system depressant.
right,
That could affect reaction time as well.
sure.
And the citalopram, that's a central nervous system depressant,
It can be depressive, yes.
and that can affect one's reaction time as well,
Sure.
particularly when we couple all three of these things together, right?
It can affect it. In some cases, it might not. My point was we have no evidence of a defensive maneuver or evasive maneuver.
All right, and since there's no evidence of it, that really shouldn't play into the analysis of whether this was a struggle or not, right?
No, that's not necessarily true. We don't have it stands on its own. We have no evidence of a defensive maneuver. It doesn't say one way or another whether or not there was a struggle for the weapon.
And are you familiar with firearms?
Sure.
And are you familiar with the term like kickback of a firearm?
Well, kickback, blowback is two different things, but okay.
Well, my
You mean
question
kickback?
today was not about blowback. My
All right,
question
kickback.
today is about kickback. Are you familiar with?
Recoil?
Yes.
Okay.
All right. And the higher the caliber of the weapon and ammunition, the more of this effect there is?
Yeah, I suppose. It depends on the weapon, though, and it depends on the ammunition fired. But generally, the larger caliber guns are going to have more of a recoil when fired.
How about a 357 Magnum using 357 Magnum ammo instead of 38?
Well, there's going to be a reasonable kickback or recoil.
And correct?
Correct.
And that's basically, force equals mass times acceleration, something like that?
Yes.
All right. In Sir Isaac Newton's rule, for every action or force, there's an equal and opposite reaction or force, right?
Correct.
All right. So bullet goes out at like 15 to 1900 feet per second, and then there's a force back on the gun, correct?
Right, but you got to remember what we're looking at is we're looking at what happened prior to the recoil, because the gun is discharged and the recoil, but the bullet hitting the person, it has nothing to do with what's happening to the gun after the shot was fired.
Well,
So that's in our analysis as forensic pathologists, we're looking at the pattern of injury that we see. We don't know what happened, whether the gun was dropped or thrown or slid across the floor. That does not affect what actually happened at the time the bullet entered her.
Okay.
And created that injury pattern.
Now, 15 to 1900 feet per second from a foot away, that's going to be a pretty short amount of time, right?
Sure.
All right. Now, if Mrs. Ward hypothetically was standing when she suffered this wound to her head, how long would she be able to stand up?
Probably not more than a few seconds, considering the blast effect and where the bullet caused injury to the brain, the brainstem, the base of the brain.
And if she had her arms raised at all from the resting anatomical position, how long would she be able to keep her arms raised after suffering that type of wound?
She's probably going to lose motor function immediately.
Okay.
and fall immediately, which is my concern about the impact and the blood being
All
on
right.
in that wall.
Back to the part where I ask the questions as the lawyer and you do the autopsy. Let me ask a question.
Well, I'm explaining my answer to you.
All right. So, if somebody is to hold a gun 180 degrees at themselves, is this anatomically the best position to get the best strength out of this finger to pull a trigger?
Oh, I don't know. Depends on the individual. They could use their thumb. I mean, who knows?
Oh,
You could bend over and do the same thing, but I think you're presupposing too many variables there.
Again, Dr. Anderson, what we do here is I ask hypothetical questions and you answer my questions. So my question to you is this the best anatomical position to get the best strength out of this finger as compared to, say, this way?
I completely do not understand your question.
Is it easier to pull a trigger when it's 180 at yourself from 12 inches away? Or is it easier to pull it when you're just pointing it away?
I don't know. Too many variables. I can't answer the question. I don't know.
Would you like to use states 20 to see?
To see what the trigger
What's
pull?
easier for you, to point that way or point this way and pull the trigger?
It would depend.
Okay.
I don't know. I have no idea the answer to your question.
All right, now, the gun was not found in Mrs. Ward's hands in those photographs, right?
That's correct.
The gun was not found anywhere near her on the ground, right?
Correct.
The gun had no blood on it, right?
My understanding is I didn't think so, but I don't know that for a fact.
Okay. And it was found in the drawer of the nightstand, correct?
I don't know where it was found. As I said, I can find my analysis to the actual injuries and not the, you're trying to expand what I'm trying to say. And I'm saying we're looking at the snapshot, we're looking at the forensic evidence. I don't know where the gun was found. I don't care where the gun was found. We're looking at the actual forensic evidence at the time that wound was inflicted.
Well, here's the forensic question. After Mrs. Ward suffered that wound, would she have been able to put the gun in the nightstand?
Well, no.
Okay. So, given everything we've discussed, gravity, the physiological effects on her after suffering this gunshot wound, if she were holding the gun in her hand like this, what would happen to the gun after it discharged into her face?
It all depends what position she was in. If she happened to be standing there, a number of things could happen. It could recoil. She could drop it down directly, presuming she was even in that position.
Again, this is my hypothetical. Hypotheticals have to be based on evidence, and we've already agreed you haven't considered all the evidence we have, right? So my hypothetical, if Mrs. Ward is holding a gun like this, what would happen after it discharged into her face? What would happen to the gun?
It could either recoil or drop to the ground.
And if it recoils, you said that she would lose muscle control immediately, right?
Yes,
So it would drop to the ground?
probably yes. Assuming she's in that position.
Of course. And in your analysis, you looked at the cloth twill test firing things like some other folks did, right?
Yes,
And in your opinion, 14 to 16 or 14 to 18 is the best approximation?
yes.
All right. No other questions. Thank you.
Mr. Jay, witness excused?
Yes, ma'am.
Thank you, Dr. Anderson. You're free to go. Call your next witness. Yes, sir. Defense, call your next witness.
Your Honor, at this time, the defense rests.
State, you have any rebuttal?
No, ma'am.
All right, ladies and gentlemen, this concludes the evidentiary portion of the trial. I have a couple of questions for you all in terms of scheduling. I'm going to let you all go for an extended lunch because we need to get the jury instructions and everything ready to go. So when we come back into the courtroom, we will proceed to jury instructions and closings. I know that some of you have Valentine's Day plans, and based on what I'm hearing, we will be able to give you the case to start deliberating this afternoon. What time do you need to break? I'll let you guys talk about this among yourselves and let me know. You can let me know through the deputies at what time you all need to break, because you can, like I told you, there's no time limit on how long you all can deliberate, and I never want a jury to feel pressured. You can deliberate as long as you'd like this evening, up to a reasonable hour, or you can tell me, we have plans, we need to break at 5 or 6, and we'll do that, and you can come back tomorrow morning and conclude your deliberations sometime whenever you get to it. Again, the whole point is I don't ever want you to feel pressured. So talk amongst yourselves, let me know how long you want to stay this evening. We do not stay past 8 normally, just because everyone else needs to get a break also. So don't talk about the case, don't discuss anything, leave your notepads in your chairs, have a good lunch, meet the deputies downstairs at 1:15, and if you'll let them know how long you guys can go this evening, that would be great. Thank you. All right, we're going to take a 10-minute break, and then we'll come back and discuss jury instructions, the one issue that we're having. And before I do that, actually, can we put Mr. Ward under oath, please? Everybody have a seat. Thanks.
Not on this, because the microphone. Go ahead now. Put it back.
No, put the ear sets on. Yeah. Thanks. Is your mic on?
It's the same. I can hear you enough now, but go ahead.
Raise your right hand and be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Ward, whatever you've discussed with your lawyers is confidential, as I've told you repeatedly. You have elected not to testify in this case. That is a decision that you're entitled to make, and you're also entitled to change your mind before I instruct the jury. If you want to testify, I will reopen your case and let you testify. So let me ask you a series of questions. Number one, has anyone, do you understand that every defendant has an absolute right to remain silent? And no one, including the court, can make them testify. You understand that?
Yes.
And you understand that if you don't testify, I'm going to be reading the jury an instruction that tells them exactly that and tells them they cannot use that against you in any way, shape, or form. You understand that?
Yes.
On the other hand, every defendant has a right to testify, and no one, including their lawyers in the court, can stop them from testifying. You understand that?
Yes.
Have you had a chance to discuss with your attorneys fully the issue of whether you testify or don't testify?
I have.
And you have, at this point, elected not to testify. Is that correct?
That's correct.
Has anyone pressured you, threatened you, coerced you, or done anything to keep you off the stand?
No.
Have you made the decision not to testify fully and freely?
I have.
All right. Thank you very much, sir.
Thank you.
Okay, 10-minute break.